July 17, 2012. This is Justice Done Dirt Cheap. We're at the Justice Building. How are you doing today?
I'm doing well.
And your name, please?
Sally Brooks.
Would you like to be interviewed?
I would.
Alright, so what would you like to speak about today?
About a very interesting hearing I just attended with Andre Murray, who was appearing in court today, having had to sign this document saying failed to appear in court, section 145, Criminal Code of Canada, and requiring him to appear in court on Tuesday the 17th of July in respect of that. So when we got into court and Andre was called, he asked if an information had been laid in respect to this charge, and then he was told that that wasn't what was on the docket for today. And what he was told was on the docket for today were two entirely different matters that he's actually been ordered to appear for tomorrow. So the court dockets actually have reversed the order of what he's been ordered to appear. So I don't know. He hasn't received disclosure, he hasn't been given the full charge. We turn up in court and they don't know what's happening, so now we don't know what's happening. So now we've got to come back tomorrow and they're going to hear all three together, and there are a lot of questions that need to be asked tomorrow. This is not satisfactory.
Yes, and that was before Justice Mary Jane Richards.
Yes, and this is a criminal court. This is people's liberty and reputations at stake. Process seems to be done back to front in Fredericton, New Brunswick. Charges are laid before the Crown sees it. Charges are laid before police actually investigate. I'm seeing people who are dragged into court on charges that are basically hearsay evidence from people who the police seem to trust over and above the alleged accused, whom they don't even question about whether they were at the place at the time of the so-called crime. The police don't investigate, they don't check alibis, they don't do anything. But they drag people to court on charges, hearsay evidence.
Seems to be a pretty shoddy practice.
It's very shoddy practice. It's very shoddy practice. It's playing with people's lives, it's playing with people's mental health, it's playing with people's jobs and homes, being falsely charged. People lose their jobs if it gets in the papers. This has to stop.
Another thing that was interesting at the hearing today was the court was presented with a power of attorney document, and the court was informed that a power of attorney would be speaking on behalf of the defendant, yet the court decided to flat out refuse to accept the power of attorney.
Yes.
And what was interesting is when the court was questioned as to, well, what is your reason for that? Is that according to the Criminal Code of Canada? Is it according to any provincial statute, any statute whatsoever, any law that can be pointed to? And the court said, basically, well, I'm just deciding.
Yes, the court basically had no good explanation. The Crown Counsel jumped up and got very agitated and started spouting that the Law Society Act prohibits it, and there's absolutely nothing I've read. I've read the Law Society Act, I've read the Code of Conduct of the Law Society Act of New Brunswick, and I found nothing that said somebody who's under duress and distress cannot have a power of attorney. In fact, Court of Queen's Bench have a rule whereby a person who is struggling or mentally ill or, distressed with this can apply for a litigation guardian. So if you can do that in Court of Queen's Bench and for the appeal court, why can't you do it in provincial court, where people are under even more stress and pressure because they could be incarcerated if they're not properly represented and are not fully able to represent themselves. And even the most eloquent of people are under mental stress and mental duress, and all it is having someone help them through, but these courts don't want that.
What's interesting is the definition of capricious is to appear to be ungoverned by laws, and if a judge cannot actually point to any statute, anything to base their decision on, then it's basically a decision that's ungoverned by laws, and that should be a reversible error in Court of Appeal.
Yes.
If the Court of Appeal is operating correctly.
What I'm sick of in Fredericton courts is lots of capricious decisions, lots of negligent decisions, lots of failure to actually even see evidence that certain people should not even have been charged with a crime. Crown prosecutors should not have accepted cases for prosecution. Why should we have to go to appeal? Why should we have to keep paying money to appeal against a judge's decision that was wrong?
Yes.
We shouldn't have to.
What people don't realize is that before a criminal charge is laid, there's supposed to be a due diligent investigation by the police, who then forward that investigation to the Crown, who then take a look at it and decide based on the fact test and the public interest test whether to pursue the prosecution or not. And for many of the people I speak to, it sounds like they've failed both those tests, yet they're prosecuting anyway.
Yes.
So why are they filling the courts with people that should not be in there?
And the third level of screening should actually be the judges, who are absolutely empowered to have an ex parte hearing to validate the charges to see if they should even proceed.
Yes.
So we have 3 levels of filters that are not working in New Brunswick courts. Certainly not in Fredericton.
Yes.
And people also need to know, if they've been wrongly convicted, they can apply for a ministerial review to the Federal Minister of Justice for Canada. Once you've been wrongly convicted, it passes to federal government to evaluate that, and it's as simple as finding the forms. A friend of mine has recently been sent a link from the Director of Public Prosecutions to the forms, and it actually is a very simple process, and you can apply if you have had new evidence turn up, or if the court has refused to actually see the evidence that you put before them.
Yes.
So that's another recourse if you have not had justice in the Fredericton courts.
All right. Any final thoughts on the matter today?
My final thoughts on the matter: just keep standing up and telling the truth. The truth will win in the end.
All right. Thank you for that, Sally.
Pleasure.